In 1789, the newly formed United States established the Supreme Court to act as the highest interpreter of its laws. From its very first sessions, this independent body was tasked with answering the nation's most explosive, defining question: who actually counts as fully included in the Constitution? This document is the 13th Amendment. Along with the 14th and 15th Amendments, it was written in the aftermath of the Civil War to abolish slavery, guarantee equal protection, and prohibit racial discrimination in voting. It is tempting to look at these texts and assume the issue of equality for Black Americans was legally settled. But constitutional text is not self-enforcing. If you read the 13th Amendment closely, you find a massive exception allowing involuntary servitude as punishment for a crime. Rights written on parchment mean very little until the judicial branch decides exactly how far those rights extend and what loopholes state governments are allowed to exploit. Before those amendments even existed, the court faced Dred Scott's legal claim to freedom in 1857. The justices ruled that Black Americans could not be citizens, explicitly stripping their right to sue in federal court in order to preserve the national institution of slavery. Decades later, in 1896, the court faced the realities of post-Reconstruction segregation. In Plessy v. Ferguson, the justices ruled that racially divided facilities were perfectly constitutional, actively building the legal foundation for Jim Crow under the doctrine of separate but equal. For the first century of its existence, the highest court in the United States did not protect Black freedom. Instead, it provided the precise legal reasoning required to legitimize and enforce racial exclusion. But the makeup of the bench changes over time, and with it the interpretation of the law. By the mid-20th century, a new group of justices began reading the Equal Protection Clause in a radically different way. In 1954, a unanimous court ruled in Brown v. Board of Education that separating public school children by race violated the Constitution. This single decision shattered the separate but equal doctrine the court had built 60 years prior. This triggered a cascade of rapid judicial action. Over the next 2 decades, the court systematically struck down state bans on interracial marriage, guaranteed the right to counsel, and upheld fierce federal enforcement against private race-based discrimination. Look at this 1954 poll tax receipt from Texas. States heavily utilized financial barriers like this, alongside literacy tests, to block Black citizens from voting, completely bypassing the 15th Amendment. The court intervened and struck these mechanisms down. To stop states from inventing new suppression tactics, Congress passed the Voting Rights Act of 1965. It established federal preclearance. If a state had a documented history of discrimination, it legally had to get federal approval before changing its voting laws. The federal government became a proactive shield. Winning case after case created a specific impression in the American public. It made it seem as though the Supreme Court would continuously serve as an aggressive, permanent defender of civil rights. That forward momentum did not last. In 2013, Chief Justice John Roberts authored the majority opinion in Shelby County v. Holder. This decision targeted the specific enforcement mechanism that gave the Voting Rights Act its teeth. The court's conservative majority ruled that the geographic data used to enforce preclearance was outdated. They argued that forcing certain states to seek federal permission violated the principle of equal state sovereignty. In a single ruling, the federal shield dissolved. Justice Ruth Bader Ginsburg dissented sharply. She warned that throwing out preclearance when it has successfully stopped discrimination is like throwing away your umbrella in a rainstorm simply because you aren't getting wet. 8 years later, the court followed up with its decision in Brnovich. That ruling significantly raised the legal bar required to challenge new state-level voting restrictions, making it much harder to prove discrimination in court. The mechanics of the court's jurisprudence have reversed. By prioritizing state autonomy over federal oversight, the modern court has successfully disarmed the most powerful civil rights enforcement tools built in the 1960s. Today, the fight over constitutional inclusion is rarely fought over explicit segregation. Instead, it is fought over complex mathematics, political geometry, and map lines. This document illustrates gerrymandering. Mapmakers strategically manipulate district boundaries to dilute Black voting power without ever mentioning race. Ongoing disputes like Allen v. Milligan rely on the Voting Rights Act to demand courts protect minority representation from these irregular maps. But this creates an intense legal paradox. The modern court is increasingly restricting the explicit use of race to create legal remedies. How do you correct targeted racial discrimination if the judicial system insists on a completely race-neutral solution? Across 200 years of rulings, a clear pattern emerges. The Supreme Court oscillates. It expands rights and protections in one era and then restricts the precise tools used to enforce them in the next. Constitutional rights for African Americans are not static guarantees permanently locked away in a vault. They are lived realities, continuously debated, and ultimately dependent on the specific interpretations of the 9 people sitting on the bench at any given moment.